Check 1 2.
Michael?
a.m. We will go ahead and call our Towing and Storage Advisory Board meeting to order. Appreciate everyone being here this morning. If you will, mute your mics unless you are speaking, just to keep our volume down. When you do speak, please remember to say your name so that Anna can keep up with everything. All right, we'll get started. We'll go ahead with our roll call and we'll give that to Miss Anna to check on everybody.
Thank you. Thomas Griffin? You're muted, sir.
Sorry about that. Present.
Jimmy Zulke?
Present.
Kyle Jackson?
Present.
James Spears? Tasha Mora?
a.m. We will
Present.
Gary Hoffman?
Present.
Charles Rash?
Present.
Ken Ulmer? And Presiding Officer Amy Milstead.
present.
We have a quorum.
Great. Thank you, Anna. Thank you all for being here again this morning. We appreciate your time and we know the dedication it takes for this board. All right. I believe Anna sent everyone the minutes from our July 9th meeting. I hope you've all had a chance to read that and check for any errors or any thing we may have need to update. Any questions on the minutes? All right. If there's no questions, I'll entertain a motion to approve these minutes.
I, Tasha Mora, make a motion to approve the minutes.
Tasha made a motion. I need a second.
I'll second.
Gary Hoffman, second. All in favor? Aye.
Aye.
Do you need a roll call on that, Anna?
I can go ahead and do a roll call. Yes, thank you. Thomas Griffin?
Aye.
Jimmy Zulke?
Aye.
Kyle Jackson?
Aye.
Tasha Mora?
Aye.
Gary Hoffman?
Aye.
Charles Rash?
Aye.
And Presiding Officer Amy Milstead.
Aye.
The motion passes.
Thank you all for your vote on that. All right, that brings us to item D on our agenda. We'll go right ahead and jump into public comment. I believe we have 3 public comments today. Anna, is that correct?
We have 2. We have one from Frank Montoya and one from Larry Cernasek.
Okay, I think we'll go ahead and start that. I would like to remind our folks that are joining us for public comment that we're accepting public comments in writing and by video conference call. We've not received comments before today's meeting. We will call upon the first commenter. Thank you for being here and we appreciate your comments. Please state your name and who you represent. You will have 3 minutes to speak on your subject. Please understand the board members are not allowed to ask questions or engage in any discussion with you about anything that is not specific on our agenda. Please also understand that we cannot hear any information about a pending complaint or anything under enforcement's case. Staff will keep time, and if needed, staff can follow up after the meeting with the commenter. All right, with that being stated, we'll go ahead with Mr. Frank Montoya. Hope I said that right.
Thank you. No, this is Frank Montoya. I'm representing myself. Just from the statement you just made, I don't think I can go into too many details around because I did make a complaint. But I would just ask the board to look at revisiting maybe current laws. And you guys have done good as far as answering my questions around this. I was kind of shocked at the lack of protection for the community with respects to people being pretty aggressive with their towing practices, specifically here in San Antonio. I had an experience, ladies moving, we know how the economy is. Right now, people are hurting. Within 20 minutes, my vehicle was towed. It was just me, her, 2 kids, and
Mr.
they had to get it
Montoya?
within 5 minutes.
Mary
Yes.
Winston here. I'm sorry to interrupt, but if you're going into the complaint, we want to just not do that right now. Your general statement, though, on protections is well received. So if you can not go into any facts of any complaint, that would be fantastic.
Yeah, understood. Okay, so the basics of it, I think that there should be more laws around signage, particularly reviewing what protections we have against outlier kind of companies like this. For specifically, a lot of these states are looking at things like 24 hours before towing people, an hour before towing people. That seems a little out of control to me. given the private nature of Texas. I mean, I love it. You know, I love the idea of private property and things like that. But it just doesn't seem reasonable for people to be taking people's vehicles in a minute, 5 minutes, and then, you know, we have the confusion of calling police. Things are stolen. The entire community is on board with. I mean, if you go one person at a time, they've all experienced this, but particularly in some of these areas by some of these companies, and they are such a small subset. What I learned from this, calling around all these different towing companies around San Antonio, they already regulate themselves. They provide pictures. Others, no. You know, they provide a time limit. Sometimes they don't tow without the citizen knowing, or they give it an hour or 2 hours. Some of them said 24. I'm like, how do you even do business like that? But 15 minutes, or maybe an incentive where the towing company were to take pictures so they have proof that they're not damaging your vehicle. I had a 4x4 truck. They had to tow it from behind. It's gone. You know, I don't know what kind of damage is done to it. So in my mind, it would be reasonable if you guys would look at other laws that maybe gave a 10 to 15% increase to these towing companies to not be just taking people's vehicles within 5 to 10 minutes, especially places that have no signage. You know, and look at the sign laws too, because the idea of putting 2 signs at the entrances of apartment complexes, these massive apartment complexes, and that being enough to warn people that they're not going to be towed when there's plenty of open spaces, and like, not a single resident knows that those things are there. I mean, you can go and take a poll. So which community are you serving? Are you serving yourself? Are you serving the community? So that is my main complaint here. Well, I'm looking for action, honestly, and just some reasonable laws to revisit moving forward for the state of Texas. That's it. Thank you, guys.
Mr. Montoya, thank you for your comment. We appreciate you being here today.
Thank you.
Our next public comment will be from Larry Cernasek.
Can y'all hear me?
Yes, sir.
Okay. My name is Larry Cernasek. I represent myself. This is my 48th year in business. And my comments are on the item F on the agenda. And I did send in stuff through the Texas Register, which I noticed in the item, it says that y'all are going to discuss the public comments that were received. But I just want to further state that this is a backdoor way of TDLR trying to regulate body shops. We are so regulated by the insurance company now, we don't need any more regulation. They set our rates, they tell us where to buy the parts, and they tell us how to fix the car, and they take no liability in that. So this is not going to affect anybody that owns a body shop because we're already regulated. Being regulated doesn't mean you have to be regulated by a state agency or have to have a license or anything like that. We are totally regulated. I have to go to JP court at least once a month to sue an insurance company because they won't pay to fix people's cars properly. The next problem is steering. The same thing as flipping. The insurance companies do this every day, 100 times a day. They're sending people's cars to their direct repair facilities, and the owner doesn't even know they're being taken there because TDLR lets them pick up a car without the owner signing. And in this proposal, they want us to have the owner sign. Well, why doesn't the insurance company or the salvage pool have to have the owner sign? So this is discrimination, flat out discrimination against businesses. So y'all need to take a hard look at this and realize that you're hurting the small business. What y'all don't understand is the towing company is the other half of the repair part. We tow vehicles in to repair them. And there's nothing wrong with that. So I've never had a complaint filed against me for this so-called flipping. If there was an issue, then why don't the insurance companies sue these guys? Okay, because when they steal a car from my shop, we charge them $1,500. I've never been sued, and I've done that probably 20 times, and they just go down the road and pay it. So, like I said, y'all need to take a hard look at this recommendation to do this flipping rule because TDLR has overstepped their bounds. Thank y'all.
Thank you, Larry. We appreciate your comments. All right. That is going to move us forward to agenda item E. That will be staff reports. We will start with the licensing division. Ms. Laura Hernandez, I believe you are going to give that report.
Yes, good morning, board members. My name is Laura Hernandez. I'm the manager for the tools licensing team, which we handle the towing and VSF licenses and applications. A couple of updates that I listed on my report. We had personnel update. We had Irma Villarreal resigned effective June 12, 2022. She went on to another state agency. Lucy Garcia retired after several years of her hard work as a state employee. She retired on June 30th. We have a new employee, Nathan Winger, who joined us on July 1st, 2022. He's quickly learning all the TOW and VSF applications and renewals. And we are conducting interviews for our 2 open positions. I provided the statistics for the tow trucks, the tow companies, tow operators.
Looks like you don't have court.
Vehicle storage facilities and vehicle storage facility employees. If we scroll down farther, I did provide some statistics for our emails that we are receiving regarding the towing and VSF programs. We are still doing those, receiving those manually. We don't have an automated process yet, but we are working on that. You can see the number of emails that come in for those particular programs. We don't have the August numbers. They weren't available at the time of this report. And we're still in process of that. If you have any questions regarding my report, I'm happy to answer any of them.
Board members, do you have any questions for Laura? No questions. We got a quiet group this morning. I'm happy to see the emails growing, Laura. I think that's fantastic. Just one more way to communicate with everyone. I know that email's the way to go these days,
Right.
and it's sure helpful.
It is. We do like the emails. We're able to respond quickly because they can reach to our team right away. They don't have to, go get filtered through us. They come directly to the team now. So it's much easier process.
Gotcha. We want to welcome Nathan, and we're excited about the new changes. Sad to see the other ones go, but we understand. So welcome to Nathan. Board members, any more questions? Okay, then we'll be moving on. Thank you for your report, Laura. Next, we will call it customer service, Jacqueline Rush.
Good morning, Presiding Officer Milstead and board members. It's good to see you today. We were asked for personnel updates and statistics, so let me present those. As we mentioned in previous meetings, we're doing a lot of hiring this year. The Customer Service Division has conducted interviews and hired for 4 roles, including a new manager, quality training and performance analyst, executive assistant, our first one, and 4 customer service representatives, otherwise known as embedded service representatives, that work on our emails and issues that get stuck in the process. Our new manager, one of 3, is Myra Rodriguez. She started at TDLR in 2015. And in addition to her quality training and performance analyst role previously, she has also held customer service team lead positions, our embedded service representative position, and CSR. She has been part of multiple successful projects in customer service, as well as contributed to creating new reports, such as the ones that we share with you all, to display the division's performance. Roxanne Olivares, she's our new quality training and performance analyst, replacing Myra. Since October of 2019, Roxanne has done exceptional work as a team lead for the customer service division of TDLR. She has set a high standard for data-driven organization, collaboration, teamwork, project implementation and coordination, and innovation for her team. She first joined TDLR as a CSR 3 in December of 2016. Additional team members we have hired include Patricia Martinez Castellan, our new executive assistant, embedded service representatives Kimberly Phillips, Elena Tori, Trin Lam, Nita Roberts. All of these were former CSRs at TDLR. Moving on to our statistics, the number of calls that we receive for your program in 2021 and fiscal year 2022 are presented. As Laura Hernandez stated, her amazing team gets emails directly to avoid a bottleneck with our area. So mostly what you're going to be seeing are the amount of calls that we get per month for the last 2 fiscal years. And I'll be happy to take any questions.
Board members, questions for Jacqueline? Everyone is so quiet this morning. Are we sure they're here, Anna? Jacqueline, so understaffed, is that one of the reasons y'all did so much hiring? I mean, don't get me wrong, I'm very excited to see the growth in your department, but I was just curious if y'all were just that far understaffed, or is it growth in general?
It is, it's a little bit of a combination. We have a mixture of folks that are leaving the state. We have a mixture of folks that are moving up through the agency. We do have former CSRs in areas all over the agency, and as well as in the division. And so when we see that movement, we need to be sure to replace those CSRs. They have a lot of questions to answer. When folks call, they're asking about not just 39 programs, but hundreds of license types, lots of different processes, and it could be from a potential licensee, current licensee. It could be from the general public, and so it takes some time to really get some good training to be able to be that dynamic and being able to answer so many different kinds of questions. So we want to make sure that we keep that CSR hiring process as a priority in our area.
Understand them. Congratulations on the new hires.
Thank you so much.
Any other questions, board members? Okay. We'll be moving on. Thank you, Jacqueline.
Thank you.
That brings us number 3, Enforcement Division. That will be Miss Natalie to report on.
Good morning, advisory board members. My name is Natalie Olvera. I'm a prosecutor in the Enforcement Division, and I'll be presenting enforcement's report to you today. First, we have the statistics through June of fiscal year 2022. The department has opened a little over 1,000 tow cases and 718 VSF cases, which is about 6% of overall cases opened. This number is staying on trend with past statistics. Of the tow and VSF cases closed, approximately 7% and 13% of those respective cases have resulted in disciplinary action, which would include commission orders, default orders, and agreed orders. For tow, the majority of complaints come from consumers. For VSF, the majority of complaints come from the department due to periodic inspections. In the case outcomes table for tow and VSF, the average penalty assessed on those orders is about $1,100 compared to $2,200 for all programs. TDL's website also has the previous 3 fiscal year statistics on their websites for all programs. Also in case outcomes for both tow and VSF, most cases are informally resolved. There's a breakdown in the table below. About 45% of tow cases and 29% of VSF cases are closed with insufficient evidence. The top violations in tow resulting in disciplinary action are towing without legal authority, criminal history, and towing without proper signage. The top violations in VSF resulting in disciplinary action are failing to timely send notification letters, operating an unlicensed VSF, and charging impound fee without listing the service performed or the date that service on the invoice. We have also included the statistics from fiscal year 2021, which largely track with the statistics just presented, but the average days to close cases has improved. In fiscal year 2021, it was taking about 285 and 344 days to close cases in tow and VSF respectively. In fiscal year 2022, we have decreased that time to 262 and 301 days, which is still decreasing. Next, we'll jump down to case highlights. First, we have Ricardo Valera, an agreed order assessed respondent a $6,000 administrative penalty for conducting illegal tows, failing to take tows to a licensed VSF, and operating an unlicensed VSF. Respondent is in the process of complying with this order. Next, we have Texas Towing Corporation, Agreed order assessed respondent a $2,000 administrative penalty for failing to take tow to a licensed VSF. Respondent has complied with this order. Next, we have TC Towing LLC. Agreed order assessed respondent a $975 administrative penalty for conducting illegal tows. Respondent has complied with that order. And then we have A1 Wrecker Service LLC. Agreed order respondent a $1,000 administrative penalty for failing to timely send a notification letter and charge fees that were not directly related to a tow. Respondent was also ordered to pay $725 in restitution. Respondent has complied with this order. Lastly, we have Joe Hill. An agreed order assessed respondent a $750 administrative penalty for failing to timely send notification letters, and respondent has complied with this order. And I'm available to answer any of your questions.
Board members, are there any questions for Natalie?
I
guess not.
No, Tasha Mora, I have a question or actually a recommendation for the case outcomes. Let me just try to scroll through. So under, it's a lot of data, which we appreciate. So for the statistics for 2022, if I scroll down to the case outcomes, we have case outcome as informally resolved. And so when I look further into what the breakdown is for informally resolved, the first line item under there is insufficient evidence. And my recommendation, and I don't know if there's a reason why insufficient evidence is actually combined with informally resolved. In my mind, I think insufficient evidence actually needs to be under this case outcomes, perhaps right above informally resolved, because that's an actual outcome. That means the department has an open complaint, concluded their investigation, and the outcome is there's insufficient evidence of a violation. And so that, in my mind, should be a line item separated out of informally resolved, but listed under the case outcomes, then followed by the informally resolved, because in my mind, the informally resolved means exactly that. That was resolved informally, where the department did not decide on whether there was a violation or not. Under case outcomes, I see that there's a lot of data about cases that resulted in a violation and what the disciplinary action may have been for that. But I think it's important for us to be able to see as a separate line item that insufficient evidence is actually an outcome as determined by the department. So I would like to recommend that that line item actually be moved to case outcomes and removed out of the informally resolved category. So then what we're seeing is we can see the insufficient evidence, how many were, the outcome was decided there was insufficient evidence of actual violation. Then after that, there's the informally resolved. I think that's a truer reflection of what the outcome is as determined by the department. I know that was a lot, but
Mary Winston, Tasha, I get it. Yeah, sorry for interrupting. I get it. I know that Natalie is reading. We have certain measures that we report and how we report them to the ledge, but how you want to see them, we'll talk, Natalie, and we'll work with John to get the clearer picture as requested.
Okay, thank you.
Mm-hmm.
Thank you, Tasha, for your comments. Ms. Winston, thank you for jumping in there. Board members, more questions for Jacqueline? I'm sorry, I meant Natalie. I apologize. Okay, nobody else? I guess that lets us move along to field inspections. Mr. Ulysses is with us.
Good morning, board members. My name is Ulysses Asio, Regional Liaison for the Field Inspections Division, and I'll be presenting the report for field inspections. On personal updates, the sub-region inspectors, James McKitchery, Roy Cantu, and Kui Kepner have been trained and released to conduct VSF storage facility inspections. Congratulations to them for being able to be in the field and conduct these inspections. For current projects, To implement TDLR sunset legislation HB 1560, the Field Inspections Division has begun development of a risk-based inspections work plan for VSF inspections. On July 25th, 2022, TDLR's Field Inspections Division began production use in the field of a new system that allows inspectors to track their inspections electronically. This new method, which we're calling e-inspections, will allow us to better serve licensees, increase our efficiency, and standardize the data we collect for each inspection. E-inspections has been launched starting with the massage therapy program inspections, and additional programs, including VSF, will be added soon. Now, since this report was submitted, we have made progress on the risk-based process in the VSF program and hope to tentatively begin implementation in September 2022. Below are statistics for the number of VSF inspections our staff has conducted during the fiscal year. And I'll be happy to answer any questions the board may have.
Board members, questions over field inspections? I think they're still asleep. Okay, Mr. Ulysses, we appreciate your report and congratulations to all your staff. I'm so happy to see y'all are getting the help you need in every department.
Yes, ma'am. Thank you.
Okay, I guess that moves us along to regulatory program management, our world famous Todd Forrester.
Good morning. I'm Todd Forrester with the Regulatory Program Management Division. We are still keeping track of all our contacts within the industry and without, internal, external, both industry and citizens, and internally with TDLR. We are continuing to monitor the web traffic for the company compliance page. We have seen a little bit of an uptick, but it's maintaining pretty steady flow of around 6%. And if you could scroll down. Current projects, we continue to work with our analytics process along with the other divisions at TDLR, General Counsel, Enforcement, Field Inspections, to look at the rules and see if we can better educate the industry, better educate the people of Texas on the laws and rules for towing and vehicle storage facilities. We are continuing to monitor the web and continuing to provide trainings online. We have recently updated the VSF compliance manual. If anybody would like a copy of it, you're more than welcome to send an email to towing@tdlr.texas.gov. It wasn't a very big change. It was updating the manual for the new forms, as well as fixing some general errors. I'm not the best speller, but I went back and edited a little bit of it to make it a little more easy to read. For outreach, again, we're continuing with the trainings. Anyone who wants to go, you're more than welcome to go. We do them once a month, the second Wednesday of each month. They're all online, so that better facilitates the people who work in a rural area, as opposed to us going out where they may not be able to go. You know, there's places in Texas where there's not a whole lot of people. It may not be worth it for us to travel, so this allows us to incorporate them into those trainings. If anybody would like to go, like to sign up, please send me an email at towing@tdlr.texas.gov. Finally, we were at the tow show. I was at the tow show. I had a great time. I this year I actually brought my wife and daughter with me. We had fun. They got to see a little bit of what I do, my interaction with the industry. So it was interesting for them, and I love talking to everybody. I was able to understand some of the problems the industry's having and hopefully clear up some miscommunications or confusions any of them had. That's something that I look forward to every year. I had a great time, and thank y'all for having me. And I will take any questions y'all may have.
Amy, I have a question for Todd. Todd, where can licensees find the updated manual?
So it's on our website under the company compliance page. It's a little bit, they broke it out. I do understand though, we're going to be looking at our webpage possibly. So if anybody wants an emailed copy of that, they're more than welcome to send me an email at towing@tdlr.texas.gov. I'm not 100% sure on how they're going to change the website or if that area is going to change. And so it might be better just to have a copy of it.
Right, I was just wanting to make sure that those who are listening, licensees who are listening, if they're struggling to find it on the website, that they at least have the email to request an email copy to be sent to them. Thank
And that
you.
one they can print out anyways if they so choose, even though there are a lot of hyperlinks that link you to all the laws and rules, which took a long time, but it's fine.
Thank you for that. Thank you for the update on that. We appreciate it.
Not a problem.
Any other board members with questions for Todd? Todd, I know it was great to see you there, and I know you got to field lots of questions, so I hope you didn't get beat up too bad, but
No,
we
it
should
wasn't too
appreciate
bad.
your attendance in our trade shows just to help keep everybody educated.
Thank y'all so much for having me.
All right, thank you, sir. No other questions for Todd? We will move on to our boss, Miss Mary Winston, Executive Office.
Well, we have one more. We have Education and Examination Division,
I
and we also
apologize.
have someone new who will be presenting.
My apologies, John. I am so sorry. John Shieldwater, please give us your report today. And I apologize. I guess I'm trying to rush through this.
Feel free to rush as much as you like. My name is John Schildwachter, and I'm first off, good morning to presiding officer and advisory board members. Today I will be representing the Education Examination Division, and I have some brief statistics to share with you today. First off, it's the tow operators continuing education course approvals. You'll see that through the current July of this year, we have 50 and then 58 total courses. Moving on down to the incident management and private property towing program curriculum. You can see the stats there below for the current fiscal year and last fiscal year. You can see those stay pretty consistent. We'll scroll down to the next page, please. And lastly, we have the invoice information there available for you through March of this year. And lastly, as an update, we've worked with the SMEs in our division to update the continuing education course approval forms, and those are actually all posted now. So we as always, we welcome your input and feedback on anything we do, but specifically on those forms as you see them. If you have any questions, feel free to contact us via our web form. That concludes my presentation for today, and I'm available to hopefully answer any questions you may have.
Any questions for Education Examination Division? All right. Well, I'm sorry you're getting off light today. Thank you so much for your report.
Thank you very much.
Okay, now that brings us to Mary. I'm sorry. It's all yours.
Madam Presiding Officer, thank you so much. I want to say thanks to everyone who is here virtually today. Me and my team are here in person. We try to thwart any issues of connectivity that we have, but please know if we do have them, it is not because everyone has not worked in the background to make sure everything runs smoothly, but there's only so much in our control. So under the Executive Office report, we start out with Sunset Bill Implementation and Strategic Planning Update. And I thought, we've done those, but I want to kind of give you an idea of how we're always working in the background just to do what's right and best for your industry and all the industries we regulate, as well as the public that we interact with and that you interact with. So we completed our strategic planning, we completed our legislative appropriations requests. So kind of goes into a loop. That's not on this agenda, so I'm not going to go into it really heavily. However, Sunset, we went over that before. We have been continued for 12 years. That report remains on our website. That means that TDLR is doing what it needs to do. We had things that we're making better, and based on that report, we are working in the background to do that continually. So then we have bill implementation. That strives directly from our legislative session. Here at TDLR, we kind of go legislative session, bill implementation, legislative appropriation requests. Then we do strategic planning. We have legislative session, bill implementation, LAR, which is our legislative appropriations request. So we're constantly running these themes in the background every year to every 2 years to every 4 years when these reports sort of overlap, but make sure that the state of Texas and the agencies that handle the regulation do so effectively. So I'm happy to state that we have posted all of these documents on our website, as well as our legislative appropriations request, which is the next document and next work product that was a part of this cycle. And please know that was a difficult document. I won't say that difficult in that we can't do it. It's all hands on deck, and we have some great hands working behind the scenes to make these things possible. So I want to go on to our next number B, or letter B. And before I read these, Todd kind of alluded to the fact that we're working on our website. Josh Schroeder, who provides these statistics, is a web administrator here, and he's our guy. This helps him know, because I say him, all of us, but him, because he has the power to change it, how well the website's working, where to find things. Todd has so wonderfully offered, hey, if you want this, just email towing@tdlr.texas.gov. I'll send this report to you. But we also want to make sure that we're not even having Todd to spend that kind of time, but that we have it available to you. So Josh is in the process of kind of collaborating with a lot of our different divisions to make sure what we need, what we think works, what doesn't work, and then he has actual factual information on what works and what doesn't work based on the traffic that we have coming to the website. So over the last 6 months, from February 15th to August 15th, Towing and Vehicle Storage Facilities Program website received over 230,000 views, and that's almost 13,000 views a day. Most of these were from from smartphone, with a third from desktop computer. As we know in this industry, you guys are out there working. So you do have to get back to that desktop computer, but most of the time you're in the field. And as it's raining now, I think Dallas has been hit by some flash floods. I know we've had flash flood warnings. And whenever I hear a weather event, I know that our tow folks are out there working and handling. I know we have complaints, and I know we have things we need to fix, and we work on that daily. But I also know how important this industry is to Texas as we go through different weather. I don't know, it's like feast or famine. It's drought, it's flood, but whatever it is, we have to roll with it. And our tow truck drivers and our tow industry and our storage facilities really help with that and help make it possible for us to continue to get to work and get to the places we need to go. Top reasons for visiting the site: consumer information about towing. Then we have laws and rules, VSF forms, how to apply for a tow truck operator license, and release of vehicles by VSFs. That rounds out that top 5. So in the coming months, and I'll say the coming year or two, because this is kind of a massive undertaking, but Josh is up for the job and we're all up to support him in the job. We will be seeing some changes, and we'll kind of give you updates as that comes along, and we'll announce the different things to our website that just make it more accessible to the public and to you. And if you have any questions, please let me know.
Thank
Thank
you,
you.
Ms. Mary Winston. Any questions for Mary from the board? Thank you for all the updates on everything, and thank you for recognizing our industry. A lot of times we just get kicked to the curb, and we appreciate that. Okay, I guess if there's no questions, that will move us along to item F on our agenda. Discussion and possible recommendation on the proposed amendments to the existing rules at 16 Texas Administrative Code, Chapter 85. I'm not going to go into all that. I'm going to let Miss Elizabeth take it from there.
You're muted, Elizabeth.
3 years in, y'all.
It gets us all.
Yes. I was saying good morning, and I wanted to echo what Mary said a few minutes ago. We thank all of you for being here. We thank all of the licensees for the hard work that they've been doing over the past few days with the flooding in Texas. My family, a lot of my parents live in Dallas. Their neighborhood flooded. So we know how serious it got out there. And in the middle of that, when I was watching the news coverage, we had all the tow drivers who were lined up to try to help motorists who were stranded on the freeway, whose cars had been floated off down the road. And so we definitely appreciate and recognize every single licensee for what you do every day, both tow and VSF licensees. So with that said, let's talk about our flipping rule, which I presented last time. If Anna can go ahead and put that rule, the text of that draft up. We discussed in depth last time the proposed changes that we were making to 85.720 and 85.721, which we affectionately call the flipping rule. And we received 3 public comments on the flipping rule. 2 of them were from associations in support of the rule as drafted. And one of them was from a person who was not in support of the rule, who has spoken during public comment and echoed the same written comments that he made today in public comment, his concerns about the rule. So I would like to address the written comments that you all have received just a little bit so we can clarify a few things. First of all, this draft rule, as you all remember, was requested by the board, by members of the industry after we passed the companion flipping rule 2.5, 3 years ago. Shortly after we passed that rule, it was requested by the board that we draft a companion flipping rule to address flipping on the VSF side. We enlisted a work group and we worked very closely with that work group to draft a rule that was fair and equitable, and to draft a rule that did not seek to regulate body shops, because we have no regulatory authority over body shops. What this rule does is simply clarify what can and can't happen prior to the transfer of, prior to the release of a vehicle from the VSF. In other words, it attempts to stop the illegal flipping of vehicles, which is the transfer of vehicles from a licensed, regulated VSF to a non-regulated entity prior to it being released from the licensed VSF. We believe that we have accomplished that here with this draft of the rule. We also have broad rulemaking authority that is delegated to the department under the tow statute. We believe that we fall well within the regulatory authority that has been granted to us to draft this rule and other rules that regulate the industry in line with the statute. All this rule does is say, until that vehicle is released, it cannot be transferred. And the only reason why we're doing this is because, as we've talked about for many years, we are seeing a rise in the illegal transfer of vehicles without consent of the consumer, while those vehicles should be sitting at the VSF waiting for either the consumer to make a decision of what to do with the vehicle, or for their insurance company in concert with the consumer and in line with their insurance contract to decide what to do with the vehicle. After the vehicle is released, a consumer can choose to transfer that vehicle over to a non-regulated body shop. Once the vehicle is released pursuant to the rules 85.710, 85.720, and 85.721, 85.710 of course already exists. 720 and 721 are the ones we are seeking to amend to specifically address flipping. Once the transfer has happened, whatever happens to the car is up to the consumer and or their insurance company pursuant to the terms of their insurance contract. We are not in any way attempting to regulate the body shop, and we recognize that we have no authority to regulate body shops. Our authority to regulate is VSFs and tow licensees, and that is what this rule does. It regulates the entities that we have regulatory authority over, and it does not seek to regulate unregulated entities. There were no suggestions for alternative wording of the proposed draft in 85.720 or 85.721. So at this point, I would recommend that we move this on to the commission for further review and possible adoption, but that is of course up to the board. So I will turn that over to Ms. Milstead for discussion to see what the board would like to do with this draft rule.
Okay, I really hope we can get some discussion from the board on this. I'd like to hear your comments, your concerns. We all read the public comment. I hope you received all of those, and I have some input, but I want to turn it to the board to see who has something to discuss.
Amy, this is Charlie Rash. You want me to go first?
Yes, please.
I mean, I'm really conflicted about the rule. I think it will probably hurt legitimate businesses because we're going to get into a situation where we have to define when the car was solicited for repair. If you can do it after the release, I'm not sure it helps at all. Elizabeth, didn't we talk about this rule being like set on a certain time to where if we do pass it, we can revisit it in 3 months or a certain period?
No, that discussion was related to the VSF forms 12 and 13, which we
Okay.
discussed at the last meeting. We would revisit those forms 6 months from the release of July 4th. So the meeting after 6 months from July 4th. So that would be January, February 2023. So one thing I want to address though, Mr. Rash, is y'all are, I think you guys are confusing the forms 12 and 13 with the rule. The forms 12 and 13 are different from what this rule seeks to accomplish. What this rule seeks to accomplish is simply to prevent the transfer of a vehicle without the vehicle owner's consent or through fraudulent means prior to release from a VSF to an unregulated entity like a body shop. Doesn't necessarily have to be a body shop, but most of the time it is a body shop. That has nothing to do with the VSF forms 12 or 13. That's a completely separate issue. And I really caution the board to not commingle those issues together because they are completely separate. The VSF's forms 12 and 13 have nothing to do with the issue of flipping. The issue of flipping is addressed in this rule. And again, what the rule seeks to do is simply prevent the transfer of a vehicle from a licensed VSF without the owner's consent or through fraudulent means. Because what we were seeing was, and enforcement has spoke about this often in many public meetings, what we were seeing is instances where consumers were getting blank pages to sign, or consumers were not aware of what they were signing, and what they were signing was paperwork to transfer their vehicle to a body shop. They did not realize that their car was going to a body shop. And by the time they realized that their car had gone to a body shop, the car had already been torn down at great expense to either them personally or to them and their insurance companies. And they couldn't get the car in any usable form at that point. So all we are trying to do is say consumer and licensees, in order to protect the bona fide legitimate VSFs from being accused of transferring vehicles to an unregulated entity without the owner's consent, we're creating this rule that puts parameters in place and prevents the transfer of a vehicle to an unregulated entity without knowledge of the consumer, which is why in 721 or 720, you have the addition of the written consent. That's all that this rule does. It does nothing else. It does not prevent the consumer from saying, well, I do want to take my body over to Howard's Body Shop after it's released from this vehicle facility. Great. You're the owner of that vehicle. You can decide what to do with it at that point. But what we are doing with this rule is preventing the unknowing transfer or the fraudulently obtained transfer authorization from consumers by unscrupulous VSFs.
I totally understand, Elizabeth. I just worry because when what we do here at my VSF is we ask the people what they're going to do with their car. And some people say, I'm going to release it to the insurance. Some people say, I want to move it to collision repair. we don't solicit collision repair, so we just take it wherever they want to do it. I just don't want to get into a problem later that my person asking what they wanted to do with their car is considered soliciting, because it could be considered that. The VSF forms, I wouldn't even gonna get into that today. I don't really confuse that with this. I mean, I think that we're gonna have to definitely update them. We can talk about that at a later time, but I know they're, like, just for an example, we had a person, a
What,
towing
Mr.
company.
Rash, the VSA forms are not on this agenda, so we can't
Okay.
go into that. I'm
Okay.
sorry, but it's not on the agenda and we can't discuss them.
You brought it up, not me. I was
I
gonna
was
leave it
simply
alone, but
clarifying the difference between, because I do believe, based on the public comment that we have received, that there is confusion between the forms and the flipping rule.
I'm really shocked we only had a couple comments, honestly, and one negative comment. I was surprised with that. I figured it would be a lot more.
No, sir. They had the full 30 days and all we received was 3 comments.
Right.
Okay. And let me remind you, Mr. Rash, that we do have the floor to make recommendations of what we want to do with this rule. So if we get, strong opinion from the board here, we can make recommendations of what we feel is the next step. So anybody else from the board that has comments on this? I know there are some towers. I know insurance companies. I mean, we'd like to hear from all of you.
Ms. Milstead, while we're waiting for anyone to gather their thoughts, I would like to clarify something that Mr. Rash said. He said he worries that if one of his employees asks a consumer, what would you like to do with your car, that would be considered soliciting. I don't believe that is soliciting. I believe soliciting is much more than simply asking somebody. But again, remember that our prosecutors have discretion to use common sense to decide when something has gone from a simple question to soliciting. So always remember that enforcement, we have some amazing enforcement prosecutors, including Natalie, who you heard from today, and they always review carefully all of the allegations in their investigation reports to determine if something is actually X, is actually what it's purported to, can reasonably be determined to be whatever it is, in this case, soliciting. So it's not something that's just sort of this obscure notion that exists out in the rule. There's actually a lot of analysis that's done behind it, and there's a lot of reasonableness that our enforcement prosecutors use before they decide to prosecute someone on any rule, and I presume the same would be true for this one.
I just want to say.
Oh, go ahead, Amy.
Oh, no, go ahead, Gary, please.
I have a comment, and without going too far into it, I know this is more of a area specific. I know the biggest issue is the Houston area with the flipping problems. And so I don't really experience the problem in my area as much. And without going into the VSF forms like you're saying, I think the outlaws exist just like they exist in towing, just like they exist in VSF and everywhere else. And I'm kind of torn as to whether it's not, I don't think it's going to fix the problem, because I think if they're going to do what they're doing, they're going to falsify the VSF and release it and do what they're doing anyway and say that, yeah, this was released and do it. That's just kind of my comment. I don't, I don't experience enough of the flipping issues to know whether this is going to help it or hurt it in which ways. And I'm kind of like Mr. Rash. I expected there to be more feedback, but it is what it is.
So I just kind of want to add to the comments, and again, the public comment as well. I mean, it was mentioned that this rule was put in place because of the bad players, and like you related to, Gary, the Houston area. This rule is to mirror the towing flipping suggestion. So, I mean, we were all aware of that. Again, Houston area, it was a huge problem. Y'all saw all the regulation that went through on that. it is conflicting because, there's a lot of tow companies that do own body shops, and therefore that's how the towing industry and the body shop business has been for forever, since its existence. That's how everybody operated. And it is going to change the way we do business. And this is where we as the board have to step up and make our recommendations. I know I have dear friends. I know our family has the body shop as well as the towing, and it is going to change the way things happen. But again, it's for the bad players. So just like every other piece of uh, legislation that comes in and regulation, it's all because of the bad players. So we all get penalized because of that. Am I happy? No. But what's the solution? We as a board, what is the solution if this isn't what the industry and the body shop needs? Where do we go from here?
Well, and I'd like to make a comment, as at least for the dialogue and discussion. So when Elizabeth was it started out with a report, I think what I heard, and correct me if I'm wrong, is that TDLR did receive 3 letters. One was not in support of the draft rule. 2 were in support of the draft rule. And of those supportive letters, one each came from the 2 towing and storage associations that serve as Texas. So I think I heard that clearly. It's also been available for public comment for 30 days. And I am aware that even at legislative meetings and sessions, tow shows and such, these were discussed to members and licensees. And so if all that's generated so far are 3 letters, 2 in support and 1 not in support, we have to listen to what the industry is saying. This came about through a recommendation of the industry, from the industry. And the industry has been given the opportunity at multiple stopping points to be able to voice. And pardon me, it sounds like the licensees have spoken or not, and not saying something about it says something about it. And so we have to listen to that and consider that and decide whether we are going to move forward and recommend or not. But I think I heard loud and clear. There's 2 letters that were in support, and those are from the 2 associations of the industry that represent the licensees.
Ms.
And
Moore,
the individual licensees were able to give public comment or respond, and we're not hearing the volume that one may think could be concerned and opposed to it. So it sounds like it's the draft is being supported by licensees so far.
Ms. Moore, just a point of clarification. The 2 letters were not from the 2 industries, they were from associations. They
Okay.
were the American Casualty and Property Association, and then the Insurance Council of Texas.
Okay, that's a massive clarification. Thank
Right.
you.
But you
Thank
are
you for
correct
clarifying that.
that you are correct that there was ample time for public comment by the association, by any association, and for the licensees. It went out for 30 days, as is the standard practice.
I think part of the problem may be that TDLR doesn't regulate the body shops, as Mr. Sarnasek put in his public comments. And so the body shop industry doesn't really see necessarily what's going on this side of it, if they're not looking at it. And the VSFs, if you don't have a VSF tow company and or body shop all combined together, if you're just an independent body shop working out there on your own, you don't necessarily know, which I know a lot of this flipping issue is coming from the ones that own all the same ones, and they're tearing it down. But the insurance company is on top of their game, looking at this and watching, whereas maybe the other side may not be watching it as close. They're not quite as big and powerful and have as much money as the insurance companies do to do this. They may be conducting their business. Just another thought and comment there.
I think that's a great point, Gary.
In response to the comments, and yeah, I was waiting on Elizabeth to chime in there, Tasha. The insurance companies, we would expect nothing different from them. I mean, that's their job to get them moved as soon as possible and to get it out of there so they're not paying storage. So I expected nothing less, and surprised there's not more in favor from insurance companies. I don't know. I'm very conflicted on this because I understand what the department is trying to do, and I understand it's all to prevent the bad players, but I also understand it's going to affect a lot of businesses out there. Um, okay, so as a board, if there is no more discussion, we have the floor, so we can make recommendations. We can move on this and let Elizabeth take it and move forward with the commission. We can table it. I don't know what other options we have, but if we're not happy with it, we need to voice it and make a decision here. So I'm gonna turn it back to the board. Suggestions, a motion to move forward or table it, whatever.
So I think, Ms. Milstead, that's gonna be the first step, is to put forth a motion. Is the action going to be to vote to move this forward? And then we can go from there.
Thank you for that. So I'm gonna need one of you board members to do something here.
You can request a motion.
I don't think I follow this enough yet to make a motion to approve it. I think I would prefer to research it a little more. I understood the towing side of it and the tow hustle, flipping it and taking it straight to a body shop, but I didn't realize that we were doing this separately, and there may or may not be a whole lot of difference, but I think I'm not gonna make a recommendation on it myself.
So just to go for Mary Winston again, just to kind of take it through the Roberts rules type of situation, we will still, if possible, put a motion forward to approve it. If that then fails, then we take another step as to what we want to do then, because we've not approved it to move forward. So then what is the next step? But we do need to take that first step. So making the motion doesn't mean just to approve or disapprove. You're making the motion just to kind of move it forward for the next level of discussion, whoever decides to do that.
Okay, so go ahead, Charles.
I make a motion that we go ahead and vote on it, I guess, just to move it forward. Still
Okay.
conflicted, but we'll make the motion just to get it up.
Thank you for
And
that.
to reiterate, a second does not mean you agree with it. It just means that you are taking the next mechanism to continue to move it forward to vote.
Honestly, I mean, I wish Ken would have been able to make the meeting because I know he has a lot of information to interject on the subject also. So that would have been helpful.
But we do have a motion on the floor. Mr. Omer he didn't contact us, but he is out there working, which we appreciate. He just couldn't make the meeting. But we do have a motion on the floor to move it forward for a vote for recommendation. And now the board someone can second that, and then we take a vote, and then we move on if that doesn't pass.
So if you second it and you take a vote, but we don't have enough votes to go through, is what you gotta do to table it? Is that what you're trying to say?
So initially, we can't table it without just going through Robert's rules. We don't table it without taking it up for a motion, right? So yeah, we have a motion, someone seconds it, then we vote. So if it does not pass, then we'll decide on what the next step is. If that's a vote to table it, if that's a vote to, whatever other action you feel that Elizabeth can instruct us on what she needs to take, we'll go from there.
Miss Milstead, if I may offer, and Miss Winston, if I may offer.
Yes.
Could we have the rule put back up? And let me walk through the rule with you all the way I walked through it last time to explain to you so that we can revisit the conversation that we had the last time that maybe perhaps may clarify or make things a little easier for you all to make a decision. All right, so in 85-720, we are adding two words, and they're the underlined words of written consent of the vehicle owner or an owner's authorized representative. And is just a grammatical correction. Written consent is our amendment to be in line with ensuring that a consumer has given permission for their vehicle to be repaired, altered, or have parts removed or replaced, right? So the entire context of that sentence is a vehicle accepted for storage may not be repaired, altered, or have parts removed or replaced without written consent of the vehicle owner or an owner's authorized representative. And as we talked about last time, that written consent seeks to protect both the consumer and the licensee from allegations from the consumer that they did not know that this vehicle was going to be repaired, altered, or have parts removed or replaced. So the written consent is a stopgap measure put into place to ensure protection for both the consumer and for the licensees if an allegation is made that a vehicle was torn down without written consent. So then in 85.721, Anna, if you can scroll up, everything in the rule remains the same until we get to B. And B is the meat, if you can scroll up, please. B is the meat of this flipping rule. And what it says is a VSF, its owner, employee, representative, or agent must not solicit a vehicle owner or representative to agree verbally or in writing to move or transfer any vehicle stored at a licensed VSF, including vehicles stored there following an incident management or non-consent tow. Right. So what this is getting at is what I said before. We're trying to stop the unknowing transfer of a vehicle that's been taken. Most often the vehicles have been involved in accidents, not all the time. And following an incident management tow, they get taken to the licensed VSF. So what we are trying to do is, again, both protect the consumer and the licensee to say, listen, we are not going to have these conversations before a vehicle is about transfer, before a vehicle is released from the VSF pursuant to 85.710 release rules. And the second is encourage or authorize a person employed by or affiliated with a non-regulated entity such as an auto body shop or collision repair to solicit or provide documentation to any vehicle owner or owner's representative that permits to the consent to repair, alter, remove, or replace parts for any stored at a licensed VSF. So what we are doing there is then saying, licensees, you have a responsibility to make sure that unauthorized, unregulated entities aren't coming on your property and persuading people to transfer those vehicles over to an unregulated entity prior to the release. Once the vehicle is released pursuant to 85.710, which is the owner or owner's representative shows state or federally issued ID, pays the associated fees for the towing and the storage, excuse me, pays the associated fees and submits one of the forms that is required under that rule, that vehicle has then been released from the VSF. Once it is released, what happens after that is up to the consumer and it's up to the body shops. They're going to do whatever they're going to do. It has no effect on the regulated entity, the licensees. All this rule does, again, and I'll say it over and over, all this rule does is prevent the transfer of a vehicle from a licensed VSF to a body shop prior to its release under 85.710. So we are stopping that illegal transfer before those release rules have been met. That's all the rule does. So once you have it released, go do with it whatever you're going to do with it, consumer. And as we talked about last time, I believe Ms. Moore asked the question of what about advertising in a VSF for body shops? You know, if somebody were to, or perhaps it was Mr. Rash, somebody brought up the scenario of what if a consumer who comes in and does everything pursuant to 85.710 and has their vehicle officially released, what if that consumer says, you have any suggestions for where I can take my car to get repaired? And the employee says, here's some pamphlets, or we have some advertisements over here, or sure, you can walk next door or down the street and talk to Ed. That is all fine. That is not an illegal transfer of a vehicle because the vehicle's already been released. So if you have pamphlets for a body shop in your waiting room, if you say, yeah, sure, you know, actually, I also own a body shop. If you wanted, we could move the vehicle over there and I could get you a quote for repair. That's all post-transfer, and we have no regulatory authority over that, and we're not trying to get regulatory authority over that. So I hope that helps a little bit. And again, I'm open for any other questions, Ms. Milstead, if anybody else has any questions, but I think walking through the rule and looking at it again, hopefully that helped to clarify some concerns in people's minds.
I think the more you clarify, the more I disagree with it, unfortunately, because the number one is going to be a problem. If you've got ads sitting there in your VSF for your body shop, whose word are you going to take that I was soliciting you after you paid me for the vehicle? And if I have to physically come pay for my vehicle or release the vehicle, however you want to term it, it's going to create more issues.
Remember that that's associated with the and
you broke up. I'm sorry. Remember what?
That there are release paperwork that you all are required to have, and if somebody files a complaint, you know that release paperwork is documentation of that release.
I think as Mr. Rash spoke earlier about, once it's released, it's over and done with. You wouldn't release your crashed car unless you know where it's going. You obviously can't take it anywhere. You have to have it towed somewhere, and they're not going to come in and release it unless they already know the place that it's going. I don't know.
And we can't discuss those release forms, but I still have a big issue with that too. So that's, yeah, because that all ties with this.
I'm just gonna offer, we just seem to have a lot of discussion, which is good, and some more questions, that this agenda item does state possible recommendation. So if no one is so inclined to make that recommendation, then Elizabeth, correct me if I'm wrong, this kind of sends you back to the table.
It either sends us back to the table or we scrap the rulemaking that the industry asked for. I mean, the industry asked for the rule. If the industry no longer wants to move forward with the rule, you're empowered to. I would say on that I think our prosecutors need this rule for both the consumer and for the licensees for protections on both sides. But if you decide not to move forward, they will move forward with their prosecutions as they always have. I think this adds an extra layer of protection for the licensees on that enforcement side, and it also helps our enforcement prosecutors to clarify what isn't allowed.
I would say that I can see where some of the concern is, and it's exactly that, is this would be a tool for prosecutors to be able to use to protect consumers and protect the industry or licensees. But the word solicit and at what point did that happen, that's up for interpretation. And so I could see the concern of this still allows for someone's own interpretation, even though that may not have been the intent of the original draft of it. So perhaps we're not ready for this proposed draft to move forward. It needs to be either reviewed further, worked on further, or dropped completely. So I think that we need to make a decision as to what step we go, what we take next.
Yes, and I do think these are your two options. You're correct, Laura. You can either drop the issue and you don't want the rule, which is fine, or you want to go back to the drafting, and we can do some more drafting on the rule.
So Elizabeth, you broke up a little bit for me, but we can either drop this completely, was your first option, and repeat that second option for the board.
Or we can go back to drafting and make some changes. Perhaps if the board has changes it would like to make today to the draft rule, we could do that. Just recognize that if we do make changes procedurally, I think we might have to send it back out to the I think it actively changes the rule. So there's that to consider too, that if we redraft the rule, it's fine if that's what you want do, then we would probably have to send it back out for republication. So we would essentially start the rulemaking process over.
So did everyone get that? Okay. So
Bits and pieces.
Okay, so yeah, Elizabeth, you're just a little choppy, but as I said at the top of the hour, it's difficult sometimes and beyond our control. We can either drop this, as Elizabeth is saying, you don't want to move forward with it. Okay, but also we can work on, you can provide her suggestions to rework this, and then it would quite possibly have to go back out for another 30-day public comment period because the rulemaking process would start over. And so we give her time to take in the input, do some redrafting, and send it out again. Typically, when we send things out and this 30-day process for public comment, we've gotten hundreds of public comment before. And we're like, okay, we got some stuff to do. We just didn't get that this time. And so with the 3 we got, we came in as drafted and we want you all to review. Now that we're back and you're like, maybe not just this language, then we do have that option of reworking it. If someone had other information or wording they wanted to supply, this would be the time to say, well, I'd like to maybe see this language, take out that language. This is your time to work with it. And then those changes would probably precipitate it having to go back out for another 30-day public comment period.
So if we feel it needs more visiting, I mean, I don't know that shutting it down completely is what we need. That's just my personal opinion. But if we wanted to revisit this and maybe rework, would it go back to the work group, Elizabeth?
I apologize. I hope you can hear me. My virtual background, that would help. It could possibly go back to the work group, or I could redraft and bring it back before the full board with suggestions for changes. And then the full board could decide whether they like those changes, don't like those changes, want alternative wording, and then we could publish. Either way, there would be input from the board. But if you take it to the work group, the full board won't see it until it's for republication.
Okay, I see Tasha. It looks like, do you have something to say over there?
I do. I would say that I agree. I do not want to just drop this, and I'm trying to craft the language that's necessary in order to make a motion about what to do next. I am interested in reworking the draft and specifically the language, even if at the expense of it has to go back out for 30 days for public comment and restart this. I think that it's apparent that we're not in agreement for the way it is now as drafted, but we are also seem to be in agreement where we don't want it just to drop. So it sounds like a rework in my mind. At the expense, and I understand the laborious part of now the committee's going to work on this again. Now Elizabeth will work on it again. Now we'll have it out for 30-day public comment. But I think that the risk of allowing it as is too great, but also the risk of dropping it completely is too great. So I think a rework is necessary. And I'd be happy to make a motion, but I just want to make sure I'm discussing that during our discussions.
So we have one motion on the floor. Keep me in line with Robert's Rule of Order. Can Tasha go ahead and make her motion now?
So, Robert's rules, we had a motion on the floor, and that motion appears to have died for lack of a second. So we will acknowledge that, and then we will move forward with the next motion from Ms. Mora.
Okay, Tasha, you want to clarify your motion?
I am going to attempt to clarify the motion, and I'm just trying to get is it 85.721? Is this what it is? Okay, just making sure.
2021.
Okay. All right, so I'd like to make a motion that we rework the draft rule for 85.720 and 85.721. Take that back for a rework. Is that sufficient?
So we have a motion on the floor again. Do we have a second?
I'll second.
Gary Hoffman seconds. Okay, do you want to do a roll call on it or, okay?
Let me get myself unmuted here. Okay, so we have Thomas Griffin,
Aye.
Jimmy Zulke,
Aye.
Kyle Jackson. I'm sorry, sir. Could you say that again, please?
Aye.
Tasha Mora,
Aye.
Gary Hoffman,
Aye.
Charles Rash, Mr. Rash,
Aye. I'm sorry.
and presiding officer Amy Milstead.
Aye.
The motion passes.
I have a question real quick on that. If you make a motion or second a motion, can you still vote against it?
Yes, you can.
Wow. Okay.
Mhm.
All right. Well, thank you, board, for all your discussion. I hope all of our listeners are paying attention. And if this goes out for public comment, the industry needs to respond. Without responses, we don't have enough information to make good decisions here. So please send in your responses when the department requests things. All right, that's going to move us along to discussion item G. This is regarding the credit card fees and possible recommendations on a work group to visit this topic a little bit more. I'm going to hand this over to Miss Elizabeth Stripmatter Salinas again. Salinas Stripmatter, sorry.
Thank you, Ms. Milstead. So we were asked during the last board meeting if the department was ready to issue any guidance on the issue of credit card fees. And to remind all of you what this was approximately 4 years ago, there was a federal case that struck down the Business and Commerce Code prohibition on merchants charging credit card fees. So basically that statutory provision required merchants to absorb any credit card fees that are charged by the bank when a consumer paid with a credit card. The Office of the Attorney General decided not to appeal that decision, and so that decision became final, and the Business and Commerce Code prohibition was struck, which opened the door for merchants, including our licensees, to then charge back the credit card fees to consumers at the point of payment. The problem that we have, as Ms. Milstead knows from conversations that she and I have had, is that it is very difficult, and you all have expressed this as well, to ascertain the amount of credit card fee from card to card and bank to bank. So what I have heard is that some merchants just across the board, I'm not talking specific to your industry, that some merchants will just set a base percentage that kind of averages out what the credit card fee is. That could potentially be problematic because the opinion stated that a credit card fee chargeback is reasonable only to the point that it does not become profitable to the business owner, to the merchant. So it's that case seemed to say, as long as you are staying at or under what your actual credit card fee is and you aren't somehow profiting from that fee, it's considered to be a reasonable fee. So the concern with just setting a blanket 3% is twofold. Number one, it may not accurately represent what the average credit card fee is. Number two, it may actually wind up in a profit making endeavor for some licensees, not necessarily all, but for some. And number two, it is difficult for us to set a base percentage over which you can't charge more than when we don't really have any data to show what the average credit card fee to a merchant is, because it actually fluctuates. Ms. Milstead has brought up an issue with me that I wasn't aware of, which is many licensees use third parties to handle those transactions. And so the merchant may not even actually know what percentage is being charged by any given bank at any given time on any given card. So in the absence of good data, I was hard pressed to recommend anything to the board or to our licensees in terms of guidance. What I'm recommending is that we form a work group so that we can have some more discussions about this. And on the table would be gathering data, would be we need people who could actually do research into this issue to find out from banks if they have data on what the average credit card fee is, or if there's anything out there that gives those averages. There is no federal law that addresses this either. So that becomes another issue. We can't look to federal regulations for guidance on credit card fees and what's reasonable. So we would discuss in a potential work group data. We would discuss issues that arise with these credit card fees and how you determine a base percentage that's reasonable to charge back to the consumer. And we would also discuss whether TDLR would issue guidance or whether TDLR would want to engage in rulemaking at the request of the board. So there's a lot of issues that are real gray in this area. So the work group would be, I think, really probably one of the hardest work groups to be on, because we're going to be looking into a big void and trying to figure out what to do with the void. That being said, the recommendation is that we do form a work group, because I, right now, in good faith and good conscience, could not give the industry any guidance, because I really have no data on which to base guidance for the industry on how to handle the credit card fee. So I would not want to give guidance in the absence of me having informed information. And I think having industry members on a work group who can give direct input on their experiences with credit card fees would help tremendously for us as a department to try to figure out what guidance, if any, we can issue on the issue of credit card fees. And I will also tell you, I have not heard, and Natalie can chime in if she's still on the call. I know she's watching. If that I have not heard that we've had any complaints about excessive credit card fees, or that enforcement has prosecuted any of those complaints. Natalie, have we received anything in the past few years about excessive credit card fees from consumers?
No, I haven't seen any, and we haven't prosecuted anything about excessive credit card fees.
So it would seem that what the industry is doing seems to be in line with consumer expectation, but I don't know that for sure. That's just anecdotal based on the fact that we've not had any complaints or prosecutions. So I leave it up to you, Ms. Milstead, to have further discussion with the board.
Well, I know just from reviewing this previously, I know Charlie and Ken and I had, looked into this for our own businesses, and there are numbers all across the board on there. And I think what the board needs to understand is that in reviewing this and whatever Elizabeth can put together for a recommendation, we have to have the support to back it up. We can't just take it to the commission and say, here, we want 3%. We have to have the information to back it up to come up with a valued number. I do feel like the community, the citizens out there are used to this already. I think that it happens so often from other vendors that they're used to paying a fee for the credit cards. But then there are industries that don't even visit that. Like I was saying, I went to a restaurant this past weekend. They don't charge a convenience fee, but yet other places do. Some of your government agencies do, and individual mom and pops do. Just depends on where you're going with this. So now that Elizabeth has scared all of you off, I really need a good work group on this. She told us how hard this work group's going to be, but I really would like to form a work group. I feel like the industry needs this. I feel like our board should do this and take the lead on this, but it's going to take research. It's going to take us, whoever gets on this board, and I'll be the first to jump on there, to research what industries are charging it. How do they base what they get to charge? And is it regulated? Is it not regulated? And to deliver this, we have a duty to the citizens of the state. However, our industry has to, hold up the rules and whatever the commission approves. I mean, I'm hearing it all across the board that fees are set in different ways. I'm hearing that federal law is 4%. I don't really know anything about that, but I'd ask you guys to think about this. If you would be so kind to get on this board and help us do some serious research on this to make a good decision, that would be very, very helpful. Any takers?
Do we have to, since it's already established that we can charge it, but I don't guess you have any way of enforcing it since we don't have the amount set. If we don't do a work group, as long as there's not any issues, can you just leave it like it is, or do you have to get something in place? I guess is kind of my question.
You absolutely could leave it how it is, hearing from enforcement that there are no prosecutions and we haven't had any complaints. And it's been almost 4 years, I believe. We're coming up on the 4 years since that federal ruling that struck down the Business and Commerce Code prohibition. So that in itself, I think, is some data that if we haven't heard consumer complaints in 4 years, that's something for you all to consider. Is this really an issue that the board explore possible guidance on, or is it something, unless it's a problem, you want to leave it alone? And that's up for you all to decide. But
So
yes,
we could just address it later if it becomes a problem, if you start getting several
absolutely,
complaints. Okay.
absolutely.
Great comment, Gary. I never even thought about that route. So with that being said, we can either form a work group or I can entertain a motion.
And I'd like to jump in because it was I who recommended that at the last meeting. And the reason I did it is as I had received word that figures they're calling right now. I apologize for that. As we were getting, the word is that some of the VSFs were charging upwards of 5% just across the board. And so that is the reason that, and we hadn't received any complaints from HPD, but we don't receive complaints because people often don't know that they're being taken like this. And I actually feel bad for suggesting that. I would be more than happy to be on the work group if one was formed. However, I'm retiring next month and will not be on the board from here on out. And so I don't want everyone to feel like I just tossed a grenade in a room and closed the door and ran off. But if what y'all are saying is true, then it very well may be that it doesn't need to be created in a work group if the state hasn't received any complaints such as this.
I would echo that. The first thing that I always ask is there a real problem? Is there a current problem? And we've just heard from enforcement. It's been 4 years. There hasn't been complaints about this. There has no one. That does not seem like there's a problem so far. I'm making my list, and that's why I'm looking at my other screen. Is do we have good data? There's no good data on this. It's gonna require an extraordinary amount, and quite frankly, we're really good at towing and extracting that level of data. We need to leave that to some other expertise if we were going to do that, rather than a committee. 2 is what's happening at the federal level. There's no federal law with guidance. Why at the state level with a regulatory body are we wanting to give further enforcement information, even best practices? So what do we want to do? Do we want TDLR to issue guidance and engage in rulemaking? I think that there doesn't seem to be a problem at the moment. And maybe we do revisit this if there becomes a problem, if there's a volume that we're seeing, not just one complaint, but we start to see a pattern. At this time, I would not want TDLR to engage in rulemaking regarding the credit card fees.
Elizabeth, Charlie Resch, isn't it federal law that you can't charge more than the cost? So really, didn't the Secretary of State, or not the Secretary of State, Attorney General, have to deal with this if there is an overcharge? Wouldn't you refer to them for this?
I'm not aware of federal guidance. If somebody has a citation for that, I would love for you to send it to me because I'm not aware of this being addressed on the federal level, but it might be, and I'm just not aware of it. You are correct, Mr. Rash, that if a allegation of overcharge is made, it probably would be handled by the Office of the Attorney General and the Consumer Protection Division as possible price gouging. But also as a regulatory entity, we would also probably look at wanting to address it as well. But again, I'm not aware of any active complaint. I talk to OAG fairly frequently, at least weekly, and no one over there has mentioned to me anything related to credit card fees. That doesn't mean it doesn't exist, but I haven't heard of anything existing over there that they're currently looking into. But you're correct. It could be handled by the Office of the Attorney General. I would imagine it could possibly also be handled criminally if it's viewed as theft. But most likely it would be the Office of the Attorney General, Consumer Protection Division, and or TDLR.
Okay.
I make a motion that we just leave it alone for now, and if we get some complaints, and then revisit it later.
I'll second it. That's what I was fixing to do.
I have a motion by Charlie Rash and I have a second by Gary Hoffman. Okay, Anna, do you want to take a vote for all in favor?
Yes, ma'am. Thomas Griffin,
Aye.
Jimmy Zulke,
Aye.
Kyle Jackson, Tasha Mora,
Aye.
Gary Hoffman,
Aye.
Charles Rash,
Aye.
and Presiding Officer Amy Milstead.
Aye.
Motion passes.
Super. Thank you. Thank you very much. And Thomas, thank you for that clarification. We appreciate your input on that because I don't think anybody remembered where that came from, but you just saved us all a lot of work. Okay, so after that discussion, that's going to move us to recommendations and items for our next board meeting. I know that we've had a lot of discussion today, so I'm just going to throw out there, I'm guessing we're going to visit the VSF rule again. Is that right, Elizabeth? That's kind of what we decided.
6 months from July 4th, which would be January, February 2023. So if we have a TOW VSF board meeting prior to then, it would not be timely. Anything after January 4th, we could talk about it. So if you did not want to have a TOW VSF meeting until then, that would be fine. If you wanted to have one before then, that would be fine too.
Well, I'm a big supporter. If we don't have to have a meeting, don't have a meeting, because I know everyone's time is very valuable. So if that would be the main thing that we need to discuss at the end of the year or the next agenda, I say we put it off, put our meeting off until January, unless there's anything else the board or industry agency feels like we need to have a meeting prior to. I mean, the next time would be November, December. Those are so hard to put a meeting together during then. Any comments on that? And after talking with Elizabeth yesterday, if we wait until January or so, then on the odd years, it's time for the TOW study. So we could do both of those in the next agenda. And then at least we'd have agenda items to put on there.
Amy, can we add the flipping rule back onto the agenda for the January meeting? And
Yes,
maybe
sir. That's
we could
the
get this done before, work, go through the work group between now and then and get this voted on and approved.
Yeah, that's the VSF rule, right? Correct me if I'm
Right,
wrong.
the VSF, the one we talked about today, the flipping rule.
Yeah, so those are the only two items that I have is the VSF rule with the flipping from the body shop to the storage VSF, and then the TOW study that comes every odd year. Is there other items that your board members would like to see on the agenda?
Maybe add discussion about the VSF forms and if there's been any feedback, complaints, positive, negative feedback on the forms that were released at the last time.
Elizabeth, will that be the right timeline to visit that again?
It would, as long as your meeting is after January 4th.
Perfect. All the more reason to meet in 23.
I'm good with January.
Okay.
I am too.
Else? Anything else for the board? Okay, so that takes us to discussion of time, date, and location of our meeting. So obviously, we've all decided after January 4th. So I don't know, Anna, do you want to throw some dates out there or?
Since it's so far ahead in the time, let's go ahead and wait, and I'll pull the board later on.
Okay, fair enough. Fine with everybody? Ms. Winston and Ms. Elizabeth, is that good with you ladies?
Elizabeth, that gives her time. So,
Does. It gives us
and
time to
the
have a work
board. Yeah.
and to do some redrafting and some more discussions.
Yes.
We
It'll
may
be a
only have,
meaty meeting.
yes, we may only have the ability to do one or possibly 2 work group meetings before then, but we will definitely have one. It's just hard when you're working on multiple programs and then you've got the holidays coming up. So I will promise you at least one more meeting with the work group where we talk about draft changes. We may not get to a second, but I will do my best to try to get to 2 meetings prior to the next board meeting with the work group.
Perfect. And I know that those of you on the board, you know who's on the work group, the rules review. I'd like to just go ahead and remind you guys, it's Tasha Mora, Kyle Jackson, myself, and Charlie Rash. I hope you guys will get some input from others in the industry. Try to do a little bit of research on your own so that we'll have more information to discuss. I know we three, or four of us, were on the work group, and then here we are bringing it to the board, and we're all over the place. So we kind of got messed up in there. So we need to do some research on that, if possible, and bring that back for good discussion. Okay, so we're gonna just wait on our meeting and time and date and all that kind of stuff. I know the agency is so excited they don't have to deal with the towing and storage industry for the last quarter of 2022. You're welcome. We're glad to be out of your hair for a few months. And if there is no other comments, I will entertain a motion to adjourn.
I, Tasha, make a motion to adjourn the meeting.
I'll second.
Kyle
Jackson.
Kyle Jackson, was that a second from Kyle? Okay. All in favor? Do we need a roll call for that?
We don't.
Okay, all in favor. Thank you all for your time, and we look forward to seeing you in the next few months.
Thank you all. You be
Thank
safe
y'all.
out there.
Thank you.